Welcome everybody. My name is Advocate Horn and this is a presentation on Section 1893 notices of the Labour Relations Act. So, what is a Section 1893 notice? It serves as a invitation or to consult with regards to retrenchment or redundancies or any other type of form of restructuring that needs to take place in terms of Section 189 of the Labour Relations Act. It normally provides consulting parties with relevant information and includes the reason for proposed retrenchments, alternatives to retrenchment, as well as normally the agenda for a consultation meeting. So in a Section 1893 notice, you will normally get the following information: the reasons for the proposed dismissals, the alternatives that the employer considered before proposing the dismissal, the number of employees likely to be affected, and the job categories which they are employed in, the proposed method for selecting which employees need to be dismissed, the time when and the period which dismissals are likely to take effect, the severance pay proposed, any assistance that the employer proposed to offer the employees likely to be dismissed, the possibility of future re-employment of the employees who are dismissed, and the number of employees employed by the employer, and the number of employees that the employer has dismissed for reasonable reasons based on operational requirements in the preceding 12 months. The reason for that is so that one can specifically determine whether this is relating to a small-scale or large-scale retrenchments, and the reasons for that we are not going to discuss in this presentation right now, but those sort of facts that one need to be determined whether a retrenchment is can be affected. We also include a sample of such a notification that normally is included in such a letter, and the information that is contained in there, you will see it basically reflects the points that we have discussed in the previous few slides. So what is this controversy around Section 1893 notices? Once we determine that Section 1893 notices for the purpose to consult and an invitation to provide parties an opportunity to enter into negotiations about those specific points that we have highlighted, one can see that in Pariati versus JR and others, and JR 1162 of 2021, which came out in June 2024, the court held that the written notice was not strictly required. So this opens the question whether one is then each and every time required in terms of the Labour Relations Act to issue a Section 1893 notice, or whether it is not necessarily. And in this specific case, the court found that it wasn't specifically necessary because the union was involved in the consultation process and did not have demanded that the full notice be given in advance. If that they did demand that the full notice had to be given, then most probably this would have basically been a requirement that had to be met. The landmark principle in these cases normally originated from the case of SASPO on behalf of Free versus Nedbank Limited, that stated that it's peremptory at a trigger of number of events and options. It's a principle, not simply something that can be ignored, despite the case of Pariati versus Sereri in the previous slide. So what does this basically mean? In short, the landmark principle states that was already decided in 2020 that when one do issue retrenchments in terms of Section 1893 of the Labour Relations Act, where it's a small-scale, large-scale retrenchment, you normally have to issue a Section 1893 notice, and the example which we've given previously. However, there might be certain exceptions that might apply, and it doesn't have to be issued each and every time. However, the principle here is that one will normally issue a Section 1893 notice. One needs to treat it very carefully. You cannot ignore the process. If a Section 1893 notice was not issued and it was required under the circumstances, it may mean that there was not compliance in terms of the Labour Relations Act. Therefore, our recommendation is that despite the Pariati case, you always need to look first at the previous Nedbank matter and the requirement that has been set there, and one need to ensure that when you deal with retrenchments that you issue a Section 1893 notice. The new Code of Conduct goes a little bit further in that it deals specifically with a checklist approach that needs to be followed when you do retrenchments and dismissals based on operational requirements. Therefore, the Section 1893 requirement is not going away, and it's always better that you do issue a Section 1893 notice before you start consulting with the other party. You can also, if you have not upfront issued a Section 1893 notice, try to correct it afterwards by issuing a Section 1893 notice, and in those instances, then the procedural requirements would have been regarded as being met once you have issued a Section 1893 notice. Right, and that is basically the very short presentation that we have on retrenchments and Section 1893 notices. The more detailed discussion will follow in other presentations surrounding retrenchments in the workplace. Thank you very much.